The morning show here on the Rise News.
The new Companies and Allied Matters Act 2020 seems to have ruffled a lot of feathers among various stakeholders in the economy, civil society, and even the church. Everyone appears to have an issue or two with the legislation. The major argument against it is that much of what it's about is already being covered by a number of subsisting laws. There are those who have expressed an opinion that CAMA 2020 is a kind of platform for realizing some sinister political objectives. Right now, we're being joined for a wider discussion on this by Liborous Oshoma, a lawyer and head attorney, Liborous Oshoma Chambers. He will also be offering us his perspective about the recent verdict of the Bayelsa Governorship Election Tribunal, which nullified the victory of Senator Doye Diri as INEC's declared winner of the last governorship election in that state, which has been generating a lot of debate within the legal community. Welcome to the program, Liborous Oshoma. Good morning.
Yeah, good morning. My pleasure.
Well, Liborous, let's start with CAMA 2020. We were told that that lengthy piece of legislation, 804 sections, 607 pages, was originally meant to promote the ease of doing business, protect the interests of SMEs. But what has become controversial is the section dealing with NGOs, not-for-profit organizations, including churches. Section 839, subsections 1 and 2, has been particularly contentious, with pastors threatening that nobody on earth can come and dissolve their body of trustees or even appoint anybody and all of that. They accuse the government of trying to cross the line between politics and religion, between law and the freedom of religion and association. Do you think that the pastors and the NGOs are correct, or you think that that law is in the best interest of everybody and that NGOs and not-for-profit organizations, including churches and mosques, are also governed by law? They are not above the laws of the land. What's your take?
Yeah, thank you very much, Doc. But before we start, I think it would be necessary for us to even read from the section. That's section 839 of the Company and Allied Matters Act, because a lot of people seems not to have even read the section before criticizing. So please, if you quickly permit me, because of time. The Commission may, subsection 1 of section 389 says, the Commission may, by order, suspend the trustees of an association and appoint an interim manager or managers to manage the affair of an association where it reasonably believes A, there is or has been any misconduct or mismanagement in the administration of the association. 2, it is necessary or desirable for the purpose of 1, protecting the property of the association, exercise of powers of trustees, application of income and property, suspension of trustees, etc., and appointment of interim manager. 2, securing a proper application for the property of the association towards achieving the objective of the association, the purpose of the association, of the property or of the property coming to the association. 3, public interest, or the affair of the associations are being run fraudulently. Subsection 2, the trustees may be suspended. The trustees shall be suspended by an order of court upon the petition of the commission or members consisting 1/5, that's 20% of the association, and the petitioner shall present all reasonable evidence or such evidence as requested by the court in respect thereof. And so, if you read this section, it is very clear and obvious that the association, the commission cannot on its own sit down and suspend trustees without a court order. The commission also cannot just, the section also, from what I have read, is not targeted at churches or religious bodies. It is a section that governs non-for-profit organization. And when you register your association as a non-for-profit organization, the government exempts you from paying taxes. And so once you are exempted from paying taxes to government, and you're also collecting monies for the benefit of that association, it is the responsibility of government now to make laws to ensure that the monies so collected, the properties so realized, are properly utilized for the purpose for which that association was set up. For us now to say, no, don't regulate. You can decide not to register as a non-for-profit and then pay taxes. And then you'll be guided by the NFIU Act. You'll also be guided by the EFCC Act and all of that. But to say that it is targeted at churches, if you read the entire gamut of that section, there is nowhere church is mentioned. Because this section is a section that guides not just religious bodies, but every non-for-profit organization, including NGOs. Some of us operate NGOs, and we receive monies from foreign donors. The government also wants to ensure that these foreign donors, these monies so received, are for promoting the aims and objectives of the association. Lastly, quickly, we have seen situations where you see laity members in church, you know, enter into fisticuffs with the pastoral council over mismanagement of funds. If you look at subsection 6 of this section, it empowers such members, instead of resorting to self-help, to approach the court for an order to suspend. And also, it is not for the commission to appoint pastors for churches. It is for the commission to appoint management consultants, like what we call receiver managers, to manage the association for at least a period of 12 months if there are infractions. And so I really do not see where churches are mentioned here or where there are sinister moves to regulate churches. Mind you, this law, the amendment to the law did not start with this administration. It started with the previous administration. And even in that previous law, if you remember also, there was a section where that attempted to even cap the age of retirement for religious organizations. But eventually, it was left for the independent constitution of such organizations to take care of that.
So what exactly do you think is going on here? Is it a case of the religious organizations being averse to accountability and transparency, or a lack of understanding of the law? Because they say, you know, this runs contrary to all the tenets of freedom of association guaranteed in the Constitution. And there's also the problem of lumping them up with the NGOs. Some will argue, perhaps, should we have a separate law? Should we have a separate consideration for them, like we have in other crimes where you have the Charities Act?
Yeah, even the Charities Act regulates non-for-profit organization. It is not for churches only.
Yes, so you have for the non-for-profit and then you have for the...
No, what is happening here, it's similar to the Charity Act. What you have here is that the only difference is that the body that is saddled with the responsibility of registering such agencies is the one also saddled with the responsibility of regulating. And so, there is no, because the section is not specifically targeted at churches, I see no reason why you should now begin to create a particular section for churches. If you do that, that is when there will be this hue and cry. This cry will be justified that the government is trying to regulate religion. Because mind you, by virtue of section 10 of the Constitution, the government cannot regulate religious organizations. That's where you are free to associate. What the government is basically doing is to say, if you are registered under the Company and Allied Matters Act by the Corporate Affairs Commission, there are rules and regulations that guides such organization. Otherwise, you have Oloku worshippers, you have Igbe worshippers who are not registered. The government tomorrow will not tell them how they would run their association, but provided, if you are running the association in your name, you must pay taxes. If you remember the Charity Commission you talk about, if you are registered, if you pay tax, or if you pay tithes, you're contributing to a charity. And also government gives you tax rebates abroad. And so government ensures that they're spending money when you pay tithes. So they ensure that they monitor how those tithes are properly spent. But unfortunately here, you are not even given tax rebate when you pay tithes, and yet we are not bothered about how these tithes are spent. What basically, no, but if the money monies is properly spent, nobody will come and begin to appoint receiver managers to say, oh, we have an order to ensure that the money is properly utilized. The only people who should be afraid are those people who knows that right from day one, even their charity commission is set up, although as charity commission, but the funds are utilized for something else. So that is where you will be afraid that government will come and take over your organization, because you are not truly using it for what you have registered it to be. But if you are spending your funds and the property of the association judiciously and keeping proper books, anybody that comes, it is not by fiat, it is by court order. Anybody that comes, it is easy for you to open the books. Some people also have argued that the fear is the fact that the way some of these things are handled, like somebody alluded to the fact that Justice Onogen was removed via a court order, and so somebody's church can be taken over via a court order, by ex parte order. But I would also want to argue that by virtue, like I said, by virtue of subsection 6, that order can only last for 12 months. And you will not sit down and fold your hand and allow management consultant or auditors, as the case may be, to come look into your books. The Act is not saying that once you are removed, or once the auditors are, the trustees are substituted, that if you are a preacher, for example, you are no longer allowed to preach in the church. No, that's not the position of the law. If you are a preacher in a church whose property is being mismanaged, the commission, by virtue of court order, can appoint a manager, in most cases an auditor, like we're talking about NDDC, to look into the books while your preaching is going on.
Well, Liborous, what the churches are insisting upon is that they should be allowed to run their business the way they best deem fit, and that the state should not interfere. But you know, of course, that NGOs are also kicking. They are insisting that that particular section 839 is an attempt to smuggle in the social media bill that was starkly resisted into Companies and Allied Matters Act 2020. Do you share that view? No.
You remember, Doc, I was here and I vociferously criticized the social media bills, and I pointed out sections by sections that offends the provisions of the Constitution. But in this case, I have read this section. This is my 4th time this morning. I do not see anywhere any similarity between this section and the social media bill. Let me also further explain that some NGO, it is not every NGO that is truly set up to as a non-profit organization that is being run as a non-profit organization. You have some NGOs that exist in private pocket. They collect money from foreign donors. Nobody even knows some of these foreign donors. And then the money is used for something else. And also for some of these churches, if you register your church under the Company and Allied Matters Act with the Corporate Affairs, under Part C of CAMA, there are rules and regulations for you to register that church. And also in the same vein, if you do not want to register the church, you can decide not to register the church and operate as a church and operate your bank accounts in your name. And then the church starts and ends with you. Nobody's talking about the spirituality. Nobody's interfering with your spirituality or the way you practice your religion. But the moment you receive funds for a registered organization, there are laws spelled out on how such funds should be managed. And so you can't say government should look the other way and allow you manage public funds the way you deem fit, despite having registered that organization as a non-for-profit. And yet you are making so much profit from that organization and you're spending it personally. That's the difference here.
Well, Liborous, the reason we're talking about Section 839 is because it's been controversial, and the churches and the NGOs have been...
If you permit me to read subsection 6 quickly.
Okay, go ahead.
It says, a court of competent jurisdiction may, upon the petition of the commission or members of the association, order or suspend any person officer, agent, or employee of the association from office or employment, provided that such suspension does not exceed 12 months from the date of the order or suspension. And it goes further. So members can even approach, if you feel that your organization, the association, is being run distinct from the aims and objective of it, members can even approach the court. So what the law has done is to empower members also to approach the court. If the commission goes to court, you have a right also to be heard. But to just sit down and say, allow me run this business the way I want to run it, is a business. There are rules and regulations for running business.
Well, quickly, Liborous, yes, I was saying Section 839 has been controversial for obvious reasons. But there are some persons who also allege that CAMA 2020 is dictatorial, and that there are other sections there that do not even promote democratic principles. Take Section 704, where a body called BRICPAN is directly written into the law with regard to insolvency practice. Now, that section is trying to correct an omission in the previous act, but it expressly identifies a private company that is not created under the Act of Parliament as the only body that can relate to insolvency practitioners. That's one. Section 78 and 79 says all foreign companies must be registered, with the exception of Chinese companies. And some people have said, no, that's unacceptable. Why the exception? And then under Section 17, you are required to give the Corporate Affairs Commission a 30-day notice, pre-action notice, before you can even challenge the Corporate Affairs Commission in court. What are your views about this undemocratic, as some people call it, provisions in this otherwise progressive piece of legislation?
Yes, first and foremost, you find out that I will also agree with you to some extent that no law is perfect. There are some provisions in the Company and Allied Matters Act 2020 that truly needs to be challenged. If you remember, in Lagos State, the environmental laws of Lagos State and then the Land Use Act also, you had similar sections that tends to donate state powers to private companies. And such laws also were challenged. At some point, I think some of those sections were expunged, like where you have environmental law donating powers to what was this former PSP operators to be the sole PSP operator. So in the same vein, also, I would frown at this section 705 that you referred to.
704.
Yeah, 704 that you referred to, that donated state institutional powers to an association to build the sole body responsible for insolvency matter. That cannot be so. But the problem that we have most times is that at inception, at formation stage, we do not challenge, we do not follow up with some of these laws. For public hearing, if you remember, look at the hate speech law and even the infectious disease bill, you saw how the civil society rose, including the press, stood up to ensure that that law did not see the light of the day, despite the zeal of the National Assembly to pass it, the sensitization created. I also did not see the press and the civil society do the same with the Company and Allied Matters Act 2020. It was as if we went to sleep, and so most of these sections slip back. A situation where you ask all foreign companies to register, you exempt Chinese companies. And mind you, not too long ago, I also had said that the way we are going, gradually we are mortgaging. If we end up not paying for some of these loans, we'll end up mortgaging some of the institutions to Chinese companies. And so that's why I also am afraid when you now have specific sections donating or empowering Chinese companies simply because they are doing business with Nigeria. If you can exempt companies that are collaborating, that have JVs, but not companies that are coming to do business in Nigeria, like the Chinese construction companies, asking them not to register here. Meanwhile, every other company is registering. So what some of us can do is to ensure that some of these sections are tailored and properly challenged in court, just like Olisa Agbakoba had done with the non-uniformity of cutoff marks. So these are public interest matters that some of us, would have to take on headlong and challenge government for. But I do not see I do not see the need for the cry for Section 839 of CAMA. I really do not see all the controversies being raised. I do not see any. Even religious bodies are not mentioned there. Organizations. And it's a section that guides non-for-profit organizations. And if it has to do with non-for-profit, you can either opt to be non-for-profit or you be for-profit organization. So you'll be exempted completely.
Okay, let's shift gear now to talk about the Bayelsa state elections and the outcomes. The tribunal gave that judgment last week, I guess, asking for a fresh election to take place within 90 days. What are your thoughts? Should the tribunal have entertained that matter in the first place?
Thank you very much. I will draw my thought from the fourth schedule, the fourth alteration number 21 to the Constitution. It's the fourth alteration number 21, Act 2017. It was the fourth alteration to the 1999 Constitution, Section 285, subsection 14, paragraph C. That section defines what pre-election matters mean. That's subsection 14 says, for the purpose of this section, a pre-election matter means any suit by a political party challenging the actions, decisions, or activities of the Independent National Electoral Commission, INEC, disqualifying its candidate from participating in an election, or a complaint that the provisions of the Electoral Act or any other applicable law has not been complied with by the Independent National Electoral Commission in respect to the nomination of candidates or political parties for an election, timetable for an election, registration of voters, and other activities of the Commission in respect of preparation for an election. Subsection 9 of that section also says, notwithstanding anything to the contrary in this Constitution, every pre-election matter shall be filed not later than 14 days from the date of the occurrence of the event, decision, or action complained of in this suit. So now let's run through what actually transpired in Bayelsa. In May 16, 2019, INEC released a timetable for nomination and substitution of candidates. For primaries, nomination and substitution of candidates. By September 13th, the ANDP sent in the names of their candidates for the election. And INEC subsequently wrote a letter that same day informing the political party that by virtue of Section 177B of the Constitution, that every candidate must be of age, must be 35 years and above for you to be qualified. And that the deputy governorship candidate of the party was not up to 35, was 34 years as at that time. The political party, recognizing the invalidity of their candidates, on the 28th sent in a substitution. INEC wrote back to say that the time for substitution of candidate had closed, and so by their action they have withdrawn from the party. On the 3rd of October, the party wrote back to INEC to say that if their candidate is not put on the ballot, INEC, that they were going to go to court. And a month to the election, specifically on the 19th of October, INEC displayed the list of candidates for the election for claims and objection. The name of this political party was not there, and they didn't go to court. They waited 100 and something days later, after results were announced, to file an action at the tribunal. And after filing of the action, and a few days later, they withdraw the action in the interest of Bayelsa. The Supreme Court delivered judgment in the matter and disqualified the candidate of the APC. The moment the candidate of the APC was disqualified, the same political party came back to the tribunal to file another action. In the first place, the tribunal, by virtue of the rule, ought not to have even accepted the first petition, not talk of the second one. And so the tribunal accepted that second petition, and then 4 of the candidates withdrew from the petition. the 4 of the parties, including the deputy governorship candidate, and another member withdrew from the petition. And the court did rule that no action or no claim shall inure against or in the benefit of any of those members. Well, and thereafter, only for on Monday last week, the court gave a judgment giving in one breath admitted that the candidate was of underage, but in another breath asked INEC to go and conduct another election. The question you will ask, quickly, the question you will ask now is, who is the valid candidate of that party, even if INEC were to conduct another election?
Liborous, you will recall that the tribunal voted 2-1.
Yes,
was a dissenting
I was coming to that.
It looks like you are putting their lordships who sat on that tribunal on trial with the drift of your contribution. But we have less than a minute to go.
Lord Denny said when a judge sits on trial, the judge is on trial. And so when you are trying a matter, you should be rest assured that the entire world is going to look at how you tried that matter. And if you remember, even at the tribunal, when the chairman of the panel was reading the lead judgment, there was a statement, instructive statement he made. He said, because he was correcting the judgment as he was reading, where you have we, he will say, they're sorry because we had earlier on agreed on this. And so if I raise all of these issues, they are not of mine, they are facts that transpired before the court. And so for us, really, for me, it is very instructive because by that judgment, what we are saying, what the tribunal is saying now is that even if a discharged bankrupt or a certified lunatic or a Chinese person, a foreigner, presents documents before INEC, that INEC does not have the right to say that these documents are invalid until somebody goes to court. Well, so what if nobody goes to court?
Well, Liborous, it looks like it's still a developing story because the Bayelsa State Governor has said he will go on appeal. And it will be interesting to see what is decided all the way to the Supreme Court. We want to thank you very much for always obliging us.
My pleasure, always.
We invite you. Thank you very much indeed.